Welcome everybody to this rapid response webinar on the COVID-19 pandemic from the American Bar Association. Before we begin, I would like to introduce Judy Martinez, the president of the American Bar Association. Judy?
Thank you, Malia, and thanks to all of you who have gathered this afternoon for this very important webinar on expanding pretrial release in the age of COVID-19. We are so grateful not only for your participation today, but for your commitment to these critically important issues for our country. And we know that making sure that we are pursuing as needed and as essential the safety and other means by which we can make sure that members of our population who are incarcerated are safe and are given the highest chances of being and continuing to be safe, whether through release, importantly here or elsewhere. We know that we have to address these issues because prisons and jails are some dangerous places to be for so many during the pandemic. Today's program focuses on efforts to secure release of those while charges are pending. This topic is so important to how we go forward as a nation throughout this crisis, because we know that so many trials and hearings are being delayed across the country, with courts working as hard as they can under very difficult and ever-changing circumstances. But we know that that means often that the time that someone is spending incarcerated and in jail is going to be extended unless there are releases. The ABA has long pushed and urged for jurisdictions to release defendants on their own recognizance unless the court determines that release on cash bail or secured bond is necessary to assure the defendant's appearance, and no other conditions will suffice for that purpose. And the ABA has fought for a very long time for cash bail reform to ensure that no one is detained pre-trial due to an inability to pay. Moreover, ABA policy long supported a presumption of release pre-trial with conditions when necessary, unless an individual is shown to present a danger to the public by clear and convincing evidence. And that goes to our long-standing standards on pretrial release. During this crisis, the ABA is working hard on several fronts, including these terrific webinars that are being put on for all of you today, through webinars in other sections, divisions, and forums, and committees and commissions of the ABA, but also through advocating by our Governmental Affairs Office, so that we make sure that the voice of the ABA, the voice of the American lawyer, is heard on issues that are critical. And through so many other means, including our recently established task force, ABA task force on legal needs arising out of the 2020 pandemic. Both civil and criminal needs are being addressed there in terms of identifying the needs, recommendations being made to the American Bar Association about how to address those needs, and mobilizing pro bono help across the country to meet those needs. It's chaired by the recently retired president of Legal Services Corporation, Jim Sandman, and you should know that in addition to the chairs of ABA entities from across the association, our important partners like the Conference of Chief Justices, the National Center for State Courts, the National Association of District Attorneys, the National Center and Organization for State Court Administrators, the Association of Pro Bono Counsel, and so many more are involved in that effort. So we are glad that you can join us today. We hope, if you're not an ABA member, that you take a look at the ABA as a direct result of your listening and viewing this webinar, because we know we have so much to offer for you in this time of need for you and for your clients. And with that, I'll turn it over to Malia Brink, and thank you all. Thank you to the panelists for all we know that you will impart your experience and your energy and your commitment and your expertise to those who are with us today. Thank you.
Thank you, Judy. I want to say thank you to the group sponsoring this program, the ABA section on civil rights and social justice, the Standing Committee on Legal Aid and Indigent Defendants, and the criminal justice section. We are actively planning additional rapid response webinars on criminal justice. So please visit the ABA website, particularly the section on civil rights and social justice for updates on these programs. A couple of housekeeping issues before we begin on the substance. I see that many of you are already in chat. That's fine, chat with each other there, but I'm going to ask that you actually use the question and answer function for any questions you want to pose to the panelists. I'll be monitoring that Q&A section and try and answer, pose to our panelists any substantive questions. We also have someone online who's going to answer any technical questions or questions about materials that you have through that Q&A box. So at the bottom, if you kind of put up there, you can pull up the Q&A box, and that will be really useful during the webinar. We'll be sharing a recording of this program to everyone who's registered so that you can share it widely within your networks. We'll also be continuing to add materials to this page relevant to this topic. And with that, we're thrilled to bring you today's program entitled, as Judy said, Expanding Pretrial Release in the Age of COVID-19. I want to first introduce our panelists. Amelia Craig Kramer is the Chief Deputy County Attorney in Pima County, Arizona, which is Tucson. We're joined by two lawyers from the New York Legal Aid Society, Corey Stoughton, who's the attorney in charge of the Criminal Special Litigation Unit, and Lauren Gottesman, who's part of their decarceration unit, which seeks to maximize pretrial release. And finally, Andrea Woods, who's a staff attorney with the ACLU's Criminal Law Reform Project. As Judy mentioned, prior to this crisis, many advocacy organizations, including the ABA, had been focused on reducing pretrial detention, particularly detention resulting from an inability to pay cash bail. While many jurisdictions have reduced or eliminated the use of cash bail, particularly for low-level offenses, more than 700,000 people across the country are still detained without having been found guilty of any crime. As COVID-19 has closed or limited courts and postponed jury trials, pretrial detention has become somewhat indefinite, and the prospect of risk posed by pretrial detention only grows. At the same time, the spread of COVID-19 has pressed advocates throughout the justice system to search for ways to reduce jail populations. Today, we're going to look at various ways that jurisdictions are reviewing and revising pretrial detention policies during the COVID-19 crisis. And to start, I want to turn it over to Andrea. Prior to the crisis, you were working on pretrial justice reform across the country. Now with coronavirus, you continue to work to maximize pretrial release to reduce jail populations. Can you tell us a little about the various ways jurisdictions are modifying or not modifying pretrial release?
Sure, thanks so much for having me. As Malia said, my day job before, 2 months ago was a bail reform and pretrial justice litigator. And so I just want to acknowledge that there's been multiple waves of that movement, and in the past, 5 or so years, a real impressive nationwide movement focused on the harms that pretrial detention caused in a pre-global pandemic world. Being in jail, even for a couple of days, was already tremendously bad for individuals and their families, their communities, and associated with poor outcomes for the system writ large. So one thing that I'm feeling really grateful for is that community organizers, lawyers, judges, all kinds of leaders across the spectrum have been ringing that bell for quite some time. And so I think in light of this crisis, right, we know that jails are going to be one of the most dangerous places in America right now. There are millions of bookings into state, local, and county jails every year, often for low-level charges. Hundreds of thousands of people will be detained based on their inability to afford money bail. That was always wrong, but that is now a real place where transmission is going to occur. It's already occurring. People incarcerated are going to be harmed, and the community will be harmed because, for obvious reasons, with a spread like that, it reaches staff, it reaches people when they are released, which almost everyone in a jail will go somewhere else in either short or medium term. And because it's going to completely burden the local healthcare system. So one of the things that I'm feeling, in the midst of this really awful time, it does feel like there's a political appetite to recognize that pretrial detention, which was already rested on such a thin reed, right? It was so hard to justify under the constitutional principles and the moral principles that we already knew to be true, that people who are in pretrial incarceration in the COVID-19 era don't belong there. There's a lot of work to be done, and I'm really glad that there are advocates on this call who can talk in a much more concrete way about their efforts locally, including on Rikers Island, which has one of the highest transmission rates in the world, if not the highest. So I'll talk a little bit. I work for a national office, and so I'm sure there are going to be folks who are listening in who know more about your state when I list it in kind of the arena of things that are going on. So apologies if I don't get the details right. But what we're seeing is, at least in the first wave, a really broad political movement to just try to sound the alarm, talk about jails and prisons, and rely on public health experts who are doing incredible work in partnership with advocates at this time. So we've seen petitions filed to state Supreme Courts to try to invoke supervisory powers, mandamus powers, King's bench powers, which they're called in Pennsylvania, through just really clever, zealous lawyering that I can't take any credit for, but I've been cheering from afar, cheering from Queens today in my apartment. A few examples to give you in that is New Jersey was one of the first states to write a letter and an order to show cause to their state Supreme Court. You heard a lot about their efforts, I think, on a recent webinar, but suffices to say they got a lot of people very excited with that great and powerful work. And one of the things that's really robust about what came out of New Jersey is that my understanding is there are just huge categories of people who are presumed released now unless a DA moves within about 24 hours to say there's a reason not to release them. So that's just an incredible valve to just kind of stem some harm. We've also seen state Supreme Court in Tennessee, much less kind of sweeping way of stepping in, but they've ordered every local jail in the state of Tennessee to submit a depopulation order to the state Supreme Court. Those plans are coming in. It does give local jails quite a bit of leeway about what they say they're going to do, but it's an acknowledgement that this is a crisis. There are pending state Supreme Court petitions, at least as of today, in Massachusetts, Pennsylvania, Hawaii, Montana, Indiana, and I believe there are many more to come because folks are recognizing that, you know, I'm a litigator in federal court and I can talk a little bit about the options there, which I think exist, and I really think we should be mobilizing there, and I'm happy to talk with anyone off after the call if you think that federal litigation would be needed, because we've been putting a lot of thought into that. But the truth is that federal litigation in this space has some serious procedural barriers. And so going into state court has just, when time is of the essence, and it couldn't be more so than now, going to our state court systems where you think you might have some real chance to do some good is probably the first recommendation that I would make. And I say that putting myself kind of out of relevance there, but I gladly say so. I also just want to talk about briefly, there's been political efforts to work with governors. Again, just go straight to the highest authority in your state and just see how far you can get. And thankfully, some governors have been really responsive. One executive order that I want to be sure to recognize, and I've shared it in the materials, is from Michigan. The Michigan governor is encouraging early release for huge categories of people, anyone in the medically risky sort of categories as we understand it with COVID-19, as well as anyone who's there for a traffic violation, inability to pay some kind of requirement of release or parole, people who, they are also suspending transfers between facilities just in an effort to, I mean, that's going to cut two different ways, I'm sure, for a lot of folks, but in an effort to sort of stop the spread. And he's mandating that every facility incorporate hygiene and sanitation measures consistent with public health protocols. So that's a really nice, fairly robust example of a governor just kind of stepping in. Governors to other degrees have stepped in. I will know less detail about these, but Wisconsin, Virginia, Illinois, Colorado, and I think I have Louisiana on here, though someone should correct me if I'm wrong about that. And then Texas shows that the governor can step in and it can be the opposite direction, right? Folks may be aware that the Texas governor issued an executive order on Sunday, essentially rendering a whole bunch of people through vaguely defined notions of prior history with violent charges ineligible for personal bond. And so that's really distressing, although many people in Texas are working really, really hard to fight that. And it's sort of a very interesting Venn diagram of just what we're talking about, which is the sort of legacy of this bail reform movement and the principles of pretrial liberty, which this flies in the face of at a time when we need release more than ever. So hopefully there will be swift action to respond to that order in Texas. I don't want to take too much more time, but I want to just emphasize the great work that local advocates, prosecutors have heard just tale of prosecutors using their leverage with the court to do some real good here and to agree to release in lots of cases. And public defenders have just been fighting this since the very first moment, really like vigorously and valiantly. And they're just impressive efforts. I couldn't even begin to name all the different states. I think public defenders have been on the front line of this fight. Because I had the sample, I shared a great bail reduction motion from Colorado State Public Defenders, though I know there are more great examples, but that one's on the materials too. Just in terms of what's working, I think aligning ourselves with public health was working. It is impossible for a jail in America to comport with the public health guidelines that the CDC is recommending all of us take. And I think sounding that message over and over again is essential. And I think it's starting to, judges who are hearing these cases are hopefully starting to realize, I think in some of the earlier efforts, they didn't quite get it. Like I'm originally from Seattle, so I was watching this ICE detention case, a slightly different arena, but similar claims in my home city very closely. And unfortunately, the judge kind of first denied this motion for relief because there weren't confirmed cases of COVID in this facility, when the whole point is you have to get people out before an outbreak starts. He's since ordered the release of a couple of people, which is good. But I think aligning ourselves with public health is really essential to kind of educating everyone about why we cannot go along with business as usual. And I'm just grateful that so much work and groundwork has been laid to have educated folks that business as usual was always wrong, but it just couldn't be any more urgent than it is now. I'll just kind of summarize with, there are also federal lawsuits that have been filed against the DC jail this week, the MDC here in New York, in the federal facility, county jail in Oregon, and then I've seen one filing in prison in Colorado, which I know is not in the scope of this webinar, but if anyone wants to talk about that, find me afterwards, because that's a supplement to the great work that's being done, but there's going to be a lot of work to do. Yeah.
Thank you. Thank you so much, Andrea, for that overview. All of our other panelists today are advocates from 2 jurisdictions that are going about the issue pretty differently. And I want them to have a chance to describe what is happening in each of their jurisdictions and how that came about and how effective it's been. So first, I'd like to turn it over to Amelia Kramer. Can you talk about how you're working to modify pretrial release in Pima?
Yes, good afternoon. I'm pleased to be here from Pima County, Arizona, which is where Tucson is located. We're a county of about a population of 1 million people, 9,000 square miles, so about the size of the state of Connecticut. And our Justice Coordinating Council has been in existence for a number of years. We're also one of the first 9 sites who joined the Macarthur Foundation's Safety and Justice Challenge a little over 5 years ago to try to reduce our jail population and to eliminate racial and ethnic disparities in the jail. So we were fortunate to have a collaborative group of the county attorney, Barbara Lawal, who's my boss. I'm the appointed chief deputy, our sheriff, police chiefs, and our courts, both our Superior Court, which handles felonies, our juvenile court, and then our various misdemeanor courts, all collaborating together and meeting on a regular monthly basis with the topic of how can we reduce our jail population. Since its peak in about 2014, where we were close to capacity in our jail, we had already been reducing it and hit kind of a baseline of 15% below where we had been close to capacity, but we had been stuck for quite some time. And I think the COVID-19 virus provided a spur to move us very quickly even farther. A couple of things happened right off the bat, a little more than 2 weeks ago. Our sheriff and our county attorney both issued memoranda indicating they would like the community partners in the criminal justice system to work to reduce the jail population. What the county attorney did was to ask all of our law enforcement chiefs and our sheriff to discontinue making arrests in cases that were not violent, not dangerous. So that would include simple possession of drugs for personal use, and to deflect those individuals to treatment. We already had a project underway that our Tucson Police Department was operating a deflection program, but none of our other law enforcement agencies were doing so. We asked that there not be physical arrests and that the evidence could be seized, obviously, and defendants could either be cited or there could be waiting until the end of the COVID-19 virus if the law enforcement agency does wish to have an arrest, but not to take those individuals to the jail. The county attorney indicated that we would not be issuing those cases. In other words, if arrests were made, that we would not be presenting those to the grand jury or to preliminary hearing for an indictment. So they would be dismissed. So there was no point in law enforcement making those arrests. In addition to that, our county attorney informed law enforcement agencies that she would not be issuing any out of custody non-arrest cases. So sometimes we have law enforcement officers that would bring to us evidence that they believe demonstrates probable cause, for example, of a series of burglaries, and would wonder what they might be doing to get more evidence to make the case, to be able to present it to the grand jury, and then to have an indictment and maybe an arrest post-indictment. And what the county attorney indicated was, look, if you don't have enough evidence now to demonstrate probable cause and make an arrest, then those matters need to be delayed. So that immediately reduced the number of arrests and the number of individuals being booked into our jail. We have cut the bookings down in half from what they were a month ago, according to data that we received yesterday from our jail and from our pretrial services agency at the jail. That's a branch of the court. The second thing that we did was go down a series of 7 recommendations from our sheriff about how he thought his jail population, existing pretrial population, as well as post-conviction probation violation population could be reduced. And so with regards to the pretrial detainees, there was a suggestion that made a lot of sense to our county attorney as well as to our public defense services agencies. We have a public defender, a legal advocate, all of which are county agencies. And then we have an office of court-appointed counsel, which hires private counsel paid for by the county. And they cover about 95% of all criminal defense matters. So we talked to them about the fact that perhaps we could get a list from the jail of pretrial detainees who had allegedly committed crimes that are not violent, not dangerous, such as simple possession of drugs for personal use, or perhaps repeated shoplifting, which if it's repeated enough becomes a felony, or some misdemeanor cases where we had detainees, all of whom were being held on bail, and that we could potentially agree to a joint motion to be filed with our Superior Court presiding criminal judge, asking her to issue an order removing that condition of bail as a condition of release for those defendants. And so in Arizona, we have very strong victims' rights, and we have a 5-day notice provision of any hearing with regards to a case involving a victim. So the first thing we did was take the non-victim cases, and last week we filed a joint motion, which was granted by the court. And on Friday, we had a release of a significant number of pretrial detainees pursuant to that order. We also, in the meantime, worked with pretrial services and with our public defender's office, which has a caseworker, social worker, to coordinate housing for the defendants who would be released who were homeless or did not have housing in the Tucson area. And so we're proud to say that we did not simply release individuals onto the street. Those who did not have housing were placed in either shelters or apartments where they could be social distancing in a manner that's consistent with protecting them from COVID-19 virus. We have another hearing coming up this Friday on the cases that involve victims. We have, some conditions of release that are being imposed in those cases, such as no return to the store where the thefts took place, for example, so the store isn't going to be plagued by somebody going back there and continuing to steal things, particularly at this time when they're struggling to keep their shelves filled. But removing the condition of bail, and we would anticipate that our judge is going to issue an order this Friday releasing more individuals in the victim cases. Again, we have lined up housing for those who are homeless or don't have housing in the Tucson area, so that they can be safe while they're out on release. And then we have a number of other groups of individuals who've been in our jail who also are being released. So for example, those who've been on work release coming in to spend weekends in the jail. The Sheriff's Department has provided, which runs our jail, has provided a list to our Superior Court of detainees that they thought safely could be released into the community. And our criminal presiding judge has sent out that list to all of the judges on the criminal bench. And each of them is going down that list and looking at their cases and initiating orders subject to objection by the prosecutor on behalf of the state to either remove the condition of bail, relieve the obligation for that individual to remain in custody, or to delay custody until the pandemic may have passed. And so where we are now is our jail population is down another 13% since the pandemic began. And one of the things that does is it affords the jail an opportunity to have quarantine areas, to have isolation areas. And as far as I know, and this was as of yesterday, we've had no COVID-19 positive cases within our jail, and we're hoping to keep it that way.
That's amazing, Amelia. Thank you so much. It's a lot. And I'm super impressed by the level of coordination. One thing I want to ask you before we move to New York, you talked about the importance of having that already existing group that was meeting related to the Macarthur Initiative and others. For people out there who don't have that, do you have kind of a recommendation for how to initiate that kind of coordination now? I mean, is kind of this moment a good moment to start that coordination if you don't have it before? Do you think that's feasible?
I think it's feasible. Obviously, we're on a Zoom meeting right now, and so with social distancing, I think agency heads can get together via Zoom. We've been meeting via conference call and via Zoom with regards to our Justice Coordinating Council. There are two models that we've seen around the country for these councils. One is led by the court, typically by the presiding judge of the highest trial court. The other is led by county or city administration. In our jurisdiction, this was a project initiated by our county administrator a number of years ago, and so we have an ongoing Justice Coordinating Council. And the Macarthur Safety and Justice Challenge Group really plugged into the existing coordinated effort among all of the agency heads. And I think, you know, one of the things that's helped us is the generation of trust over the course of the years of working together. So when the idea arose to try to come up with a joint motion to the court, we had good collaboration between our office representing the state and our public defender, who was able to take on representation of clients from all of the other public defense agencies, as well as court-appointed counsel, who gave him authority to negotiate on their behalf with us. So we were able to very expeditiously get a list from the jail to the public defender, have his attorneys, literally I think they had more than a dozen attorneys spend an entire weekend going through that list, get us a list. We had a number of prosecutors go through the list, and within 4 or 5 days, we were able to come up with a joint motion that we could present to our presiding judge. And all of us know each other, trust one another, and have been working together. But I think there's a lot of motivation right now in a lot of different jurisdictions to get something like this started. And all it really takes is putting together a conference call or a Zoom meeting of the agency heads to start the dialogue about these issues.
Thank you. That's amazing. Corey and Lauren, I know New York City has had a slightly different experience and way of going about seeking expansion of pretrial release. Can you talk to us a little bit about what you all are doing and where it stands?
Yeah, thanks. So I wanted to start by just picking up on something someone alluded to earlier, which is just emphasizing the seriousness of the situation in New York. New York is the global epicenter of the virus at this point, and more specifically, Rikers Island is the most dangerous place on the planet Earth when it comes to COVID-19. This morning, the data is that there are 184 people in the jail who are incarcerated people, and another 169 staff members working on Rikers Island who are infected with the virus. And that comes on the 19th of March, there was one. So the rate of increase is astounding. The attack rate of the virus is 77 times higher than the American national average attack rate. So it is a problem that is completely out of control. And it's out of control for the reasons that we know, which is that have been said before, that Andrea referred to earlier, which is that it is just, I can't sit here and tell you that the New York Department of Corrections isn't doing anything. They are doing things, but it is not possible to control this virus in a carceral setting, because the only way to prevent it is social distancing and, frankly, levels of hygiene that are just not achievable in a prison and jail setting. And with that reality, for weeks now, the major push has been to focus on release and the acknowledgement that our calculus, as Andrea was saying, in the best of times, we've been pushing for more people to be released, and we can't justify pretrial detention, but that calculus is just in a whole different place right now, including from a public safety perspective, because public safety at this stage for all of us is really about safety from this virus. So we've been focusing on strategies for release. And although what's getting all the hot attention is our mass writ litigation strategy, which I will talk about, it's really, we have a multi-pronged approach. And the cooperative approach that Amelia was laying out, that has also been happening in New York. It's not that that's been absent. It's just that process in New York also has, limits. And so we did start, with that dialogue amongst prosecutors and policymakers in the mayor's office and the governor's office. And that process wasn't completely fruitless. That process did result in the release of many people, a couple hundred people. But we're talking about Rikers Island, where when this all started, there were 5,300 people on Rikers Island. And so releasing, a couple hundred is not really going to get us where we need to be. So there were efforts, there were kind of cooperative efforts, and those efforts actually are continuing to happen. As we speak, there are dialogues happening between legal aid society lawyers and other defender organizations in New York City, and district attorneys' offices, and chief administrative judges in each of New York's 5 boroughs, to try to agree on getting more and more people out. And we continue to release kind of a handful of people every day just by agreement. The problem is that, again, that's not enough, right? If we just had that process going, we aren't solving the problem. It's not solving the problem, and the data doesn't lie in that regard. So we have also litigated, and we have done that. Again, we've done a few individual writs of habeas corpus on behalf of some individuals, which Legal Aid's a very big organization, so some of our trial attorneys have just gone ahead and said, I'm going to file a writ for my client, and that's completely consistent with the kind of larger strategy. But we knew, for a couple of reasons, it made sense for us to also file what we have now ended up filing, which is a series of writs on behalf of anywhere. Our mass writs have been anywhere from about 38 people to well over 100 people at a time, falling into different categories and kind of dividing amongst the boroughs in New York. Our first, and those reasons were, first, the process, we needed to kick the political process in the butt, if you'll forgive me. It wasn't, we could see that process was reaching its kind of natural first break point, where everyone starts to say, this is as far as I'm willing to go, and we needed to push it farther. And the mass writs were actually very successful in doing that. It was not until we filed our first mass writ that the mayor or the governor of New York came out and said, I'm actually going to release hundreds of people. And the governor still hasn't followed through on his pledge, which he made last Friday, to do that. But the mayor has released several hundred people, including mostly focused on sentenced people. So these would be what we call city time. So people who are serving misdemeanor sentences on Rikers Island, many of whom were kind of near the end of their time anyway. It's been our experience in New York that actually that group is actually the most politically palatable, much more politically palatable for political actors and the district attorneys to release than pretrial detainees. And I think that, I mean, I could speculate as to why, but that's been our experience. I think it's basically because, they've been punished, and a little less punishment doesn't feel as threatening to the criminal justice system as the notion of releasing somebody who's facing a trial. So the mass writs succeeded in that regard, but they've really been a mixed result on litigation on their own terms, as strategic litigation often is. Like, its best success is actually engaging the relevant actors and raising the profile of an issue. We've filed in total three mass writs. The first one we filed in Manhattan on behalf of pretrial detainees, as well as people held on parole hold. So I'm sure the system varies across the country, but in New York, a very large percentage of the people on Rikers Island are actually there on parole holds, many for technical parole violations, like missing a meeting, others on parole violations accompanied by a minor misdemeanor crime that may or may not be what the parole violation is also about, but would otherwise be out, not on bail, if it was just about the misdemeanor pending charge. So really it's the parole hold that's holding them in, a lot of them. And when we filed the mass writ, one of the things that was happening was that while we were getting some engagement from district attorneys and the mayor's office on the need to release people, we were getting absolutely no engagement from the state Department of Correctional Services, which manages the parole system, and the governor's office. There has now been some engagement, but actually, to be honest with you, it's still very little. And so we needed that litigation to dislodge the resistance at the state level to dealing with the parole problem on Rikers Island. So we filed that first mass writ in Manhattan and promptly lost it, which we did not press release. So people don't remember that. It was only a couple weeks ago. And we have since, but on the day, I will tell you, I think kind of looking back, while I think on the one hand, it was really important to press as fast and hard as we could, given the crisis that was unfolding. On the day we filed that writ, there was one case of COVID-19 on Rikers Island. The very next day, there were 21. And now 2 weeks later, there are 190 or whatever it was I just said. So it's interesting, I think, to reflect on how in the later mass writs where we started to see success, it really coincided with the data catching up with what we were trying to say to judges, which was that inevitably there is going to be a crisis here. But we were, speculating. I mean, I think it was more than speculation, but I think we were in a different position. So we then filed a follow-up writ in Manhattan State Court on behalf of about 40 additional people who, just to be perfectly honest with this group, were people that we hadn't gotten the information on yet to join in the other writ. It's a big system and we were moving as fast as we could. And that writ we won. We didn't win for every single person in that writ. It's a little bit more complex than this, but the judge did, because it was only about 40 people, the judge said, look, I'm going to look at the individual circumstances. And by and large, we succeeded in getting people out who, I'm sorry, I should have said this in the beginning, this whole writ strategy focuses on medically vulnerable pretrial and parole hold detainees. That's really a critical element of this. And I should say, it's based on a constitutional due process claim, a state and federal constitutional due process claim that their continued incarceration is deliberate indifference to serious medical need. And so our focus has been on people who are medically vulnerable, defined by medical experts, including the New York Board of Correction, which is our oversight agency, which is staffed by correctional medical professionals and other medical professionals who have identified both certain medical conditions and age as risk factors. So our writs were on behalf of anyone over the age of 50, which is for someone who's approaching that age. I know that, and to be honest with you, we have had a hard time convincing judges who tend to be in that age bracket that's the right line, but that's what the medical professionals are saying, and we're just following what they say. and then, or who have what they call comorbidities. So heart conditions, lung conditions, certain kidney and autoimmune deficiency, autoimmune conditions, but basically following the CDC's guidelines here. And so on our second mass writ, we succeeded, I mean, again, this is a little bit of an oversimplification, but we succeeded on getting the sick people out, but not the people who were simply vulnerable by reason of age. That alone, I think the judges were kind of not ready to say that they should be, released, that was a constitutional violation. And then in our third writ, we filed a writ on behalf of people who were solely held on technical parole violations. So these are people without additional criminal charges. These were people who only missed a meeting or had a dirty test. And that writ was on behalf of 106 people. And that writ we won outright, with just categorically, which was really a success, I think, especially at that stage. Having lost one and kind of partially lost one was kind of beyond my, and Lauren, I think, would agree, our wildest imaginations. It happened in part because the city, which really has no horse in the race for parole violations, came in and said, look, we agree with that, with legal aid. Those people should be out. And I think that really helped, as you might imagine. I think it helped that we'd started to get momentum, because by the time we got that argued, the data was so terrible already. And also we had succeeded in getting the mayor to make some bolder statements on the idea of release. So the notion that people should be let out was starting to become a normal thing instead of a crazy thing public defenders say. And so I think that really helped. And since then, we continue to press this strategy forward, because the truth is the political process is still not getting Rikers where it needs to be, and Rikers continues every day to become a more dangerous place for all of the people who are still inside it. There are still 4,563 people as of today still inside Rikers Island. And so we today filed a motion to reconsider the denial of our first writ, in the hope that the changed information will result in a different approach. We will also shortly be filing another series of writs for parole violators who do have pending criminal charges, but many of whom would be out because they're not bail eligible offenses, those crimes in New York. And so we're going to keep trying to push forward and push that process to make sure we get as many people out as possible. But again, I think it's worth emphasizing that even if we succeed, these are only the medically vulnerable, defined by comorbidities and age. And what isn't happening right now is a broader look at why are some of the people who are maybe 45 or 50 but don't have asthma or heart disease, but are going to get this virus because they're in Rikers Island, but are there pre-trial and presumptively innocent. Why are those people? We've got to start thinking even bigger. And so we're at Legal Aid, we're really just on the cusp of thinking about what we do next. Lauren, is there anything you want to add to that?
You covered it. I would just add, I think, and Corey touched on this, the importance of individual advocacy that so many of our lawyers are doing, and that just to emphasize that we are doing it simultaneously. And while some actors have taken issue with that, I think it's been successful. And I'm smiling because I remember during our first mass writ, it was brought up by opposing counsel that we had just earlier that day made an argument about one of our named petitioners in our mass writ, and the judge assumed it was an oversight, and we corrected him, no, it's not an oversight. We're actively litigating for each and every one of our clients as best as we can on all levels. And I think when we first filed that first mass writ, it was on behalf of 116 of Legal Aid's clients in Manhattan. And that was filed on March 19th, denied on March 20th. Today, April 1st, 22 of those 116 folks are out based on either negotiations between the prosecution and the individual attorney, or subsequent follow-up individual bail applications by the individual attorney. So the sort of dual-pronged, multi-pronged approach is really happening all at the same time.
Let me ask a couple questions about the situation in New York, but before I do, I want to pause and say that reducing Rikers from 4,300 to somewhere between 4,500 and 4,600 is no small feat. I mean, that's quite a remarkable achievement. At the same time, my brain goes to what we said in 6 years, we're going to get Rikers down to 3,300, and get rid of it. So we really ought to be able to do that now. And I appreciate that you continuing to push. Let me ask you about one of the things Amelia talked about in terms of the deflection piece, because I do think that some of the real people at risk are the people who every single day get put in for the first time, either before their initial bail hearing. Is there any effort to reduce custodial arrest and reduce the new influx of people into Rikers and exposing new people? Can you talk a little bit about that?
Yeah, there has been. There actually were efforts to do that, leading into this, and I think it's worth saying, worth reflecting on the fact of how much of the criminal justice reform advocacy from New York advocates and national advocates has made such a difference in making what is unquestionably a catastrophe a little bit less of a catastrophe. I mean, Rikers, you're right to point out that we've gone down from about 5,300 to, what did I say, 4,500 in the course of a little over a week, which is incredible. But it was 8,000, wasn't it 8,000? I don't want to, yeah, it was 8,000 not that long ago. And we got down to, it was just, I think at the beginning of March, it was just under 6,000. So, there were reductions have been happening all along, and that's critical. And a big part of that is bail reform that happened in New York, which, by the way, right now as we speak, we're in the middle of a legislative battle where the governor and the New York State Senate, which is controlled by the Democratic Party, has proposed rolling back our bail reform, and this assembly, the New York State Assembly, is the last bastion to hope that the budget that's getting voted on literally tomorrow, on Wednesday, they postponed the vote to Wednesday now, doesn't roll back these very reforms that I'm praising, but we did reduce that population. And part of the bail reform included a requirement that there be less arrests and more desk appearance tickets. Now, those still bring people through arraignments, where I must say arraignment holding cells are also big points of transmission for this virus right now, but it's certainly better than being on Rikers. So that's happened. We've worked on now since COVID, which is really what your question was. Of course, the defender organizations and many other organizations have made requests on this, and we have seen a proportional drop in misdemeanor arrests since the virus happened. But having said that, the NYPD has insisted that they will not change their strategy. Their line, Commissioner Shea's line, has been, it is business as usual as far as we're concerned. We have seen the district attorneys of New York be much better on this. The Brooklyn district attorney, for example, has been very clear that he's going to decline to prosecute even more than he already has some decline to prosecute policies. So there is real movement on that to kind of address it in that way. But I will tell you, there are still people coming into Rikers every day. And from what I can tell, looking at the data, the principal driver of that remains parole violations. And so that's not to say there is not work to be done on the arrest front too, and the NYPD front, but what remains really shocking to me in this moment is the degree to which the parole system, which, by the way, on the process side has ground to an absolute halt, and there are not any preliminary hearings happening, and we have no idea, and all the deadlines has been suspended under the emergency orders, and nobody's progressing, as far as we know, towards final determination. So people who are being brought into the system are being sent into a black hole and sitting on Rikers. And yet we continue to see parole violations streaming into the system. And that's a problem that really is crying out for more action.
Thanks. I also want to talk a little bit about some things that may impact your ability to continue to make arguments, particularly the spread of COVID-19 in Rikers, because New York is the tip of the spear, right? You're going through this first. And I think the timing of these things is critically important. I worry that you're going to face significant pushback on writs to get people out by saying that Rikers is the most likely place, as you actually said, to have been exposed. And that once someone's exposed, the kind of community interest is to keep the broader community safe. Are you facing that? Have you thought about how you're going to argue that? And has it actually played out at all?
Yeah, it has. And, thank you for raising that, because a lesson learned, we have now got in place a task force within the Legal Aid Society to focus on reentry issues, including these issues. And I wish we'd set that up a week before we finally did. So for all of you listening out here and thinking about this, do that now. We are now seeing that more of our clients who are calling us and asking for help are not just vulnerable, but actually have COVID-19. And there are much harder questions about what to do with that population. For now, my understanding of the process, and we've been in communication with the Department of Corrections for this, is that people who are released who are tested positive are released to a hospital with a medical discharge plan. Is that always going to happen in practice? Is the system going to break down? I mean, these systems do break down, but that seems to me the right approach. And it looks like the players are in agreement that that's the right approach. So I'm hopeful that that's what will continue, but it is starting to happen. And we have had judges who have released COVID positive clients. We've also had judges that have said, I'm not going to release this person. And where that latter has happened, it will be because the judge is concerned that that is not the right decision for that client in that moment. And usually something else too, like some other hesitation to release the person. We haven't had judges who are going to hold someone in who's like, on a misdemeanor or whatever, just because they're COVID positive. I think the judges all understand that Rikers is no place to be. But we have seen, I will tell you, this is an argument that the prosecutors are making right now. They were making it from the very beginning, actually. They were making it in ways that I think at first were not credible, but now I think raised that genuine issue. They were making arguments that like actually Rikers is a better place for people to be, which is, thank goodness. I think the judges, in defense of rational discourse, like the judges were like, I'm not buying that, and that was not going to fly. But there were players in our system who were making that argument, and I think it's definitely one to anticipate and to be ready for. And I think you've got to be. It goes back to we got to be those holistic defenders, right? That we're not going to be effective for our clients if we just think of ourselves as people who get them off from the crimes, right? We've got to be thinking about the universe of services that they need, or we're not going to be able to do what that core of our job of getting them their liberty.
I would just add, if I may, on like sort of an anecdotal level, I don't know the numbers of this, but I think it did get some press that through some coordination with defense providers and social workers and CHS, Correctional Health Service discharge planners, there are some folks who have tested positive who are advocating for release, who, if they don't have isolated shelters, may be able to be set up in individual hotel rooms that are now not occupied in the city. I don't know the details on that, so I don't want to speak about it at length, but I just want to add that to say that I think with social workers and health providers, there are certainly creative ways that we can all sort of collaborate and work together to assure that just because of a concern that someone doesn't have housing shouldn't mean that they're therefore relegated to Rikers Island.
Right.
And it's been a really interesting dynamic about this, which I said very briefly, that this has been my experience anyway, Lauren, and I think yours as well, that the correctional health experts in the system are they get it. Like they really want to save people's lives. And it's the security side and the political side where the resistance is coming from. I don't know if people have been following this, but we've certainly been making great use of the fact that Rikers Island's own correctional health experts have been tweeting aggressively about the need to release more people and decrying their own organizations. Not decrying the efforts, actually saying, Ross McDonald, who's the chief medical officer at Rikers, said, I think I'll get it right, but he said, look, we are moving mountains to save people's lives. And here we are doing everything that we can. We are doing everything right, he said, but we still can't control this. We've got to focus on releasing more people. And I think that that's a really powerful alignment of interests. And I think they will be listened to in a way that, you know, the defender organizations won't always be listened to.
Can I just briefly, just to underscore the point that Corey and Lauren are making, that argument that maybe people are safer in custody, particularly in places where that's where they have health insurance. Like, we are definitely seeing that play out in the country. And I think governors of both Maryland and Arizona have essentially gone on record saying as much. So that both kind of furthers the point of like the time to act is now, and we'll be looking into the really creative and great advocacy that Legal Aid Society and others are doing here with the kind of, just because you've had an outbreak does not mean you get to kind of sit idly by and let it spread. So I think it's just great to hear about that example with the hotel beds. Thanks.
Yeah, I want to kind of parse apart part of those and bring more of you into the conversation. One of them is about this kind of medical legal partnership in seeking some of these release efforts. I think we have seen that the more successful writs have included things like affidavits from medical professionals about release and addressing some of these questions that I think can create fear, like, do you release someone who is positive and under what conditions? Amelia, have the kind of medical side of the detention industry played a role in either setting your criteria? Like, what has been their role in your program, and how has that partnership worked?
Well, as I indicated, first of all, as of yet, there's not been any positive tested case of COVID-19 within our jail. But one of the things that we have initiated was, as I mentioned, trying to find housing and appropriate placement for individuals who would be released from the jail, who are homeless or don't have somewhere else in Tucson to go. And part of that for us was, our jail is in a remote area. We got cooperation from our sheriff's department to provide transportation to the housing. We worked with a case manager, social worker at the public defender's office, with our pretrial services division within our superior court, and with an existing partnership that we have working with our problem-solving courts, our drug courts, to connect up defendants with housing when they're in those specialty courts, and also in a felony drug diversion program that we have. So we had existing partnerships among the criminal justice agencies and community-based social service agencies that provide housing, treatment, both behavioral health and medical treatment, food and transportation. We were able to plug into those networks. It was actually initiated by our office, I'm proud to say, the county attorney's office, to work with public defense services, with pretrial services, but also with those community-based agencies to secure beds for housing prior to release, to secure transportation to that housing, to make sure that there would be food, that there would be medical care, and that behavioral health care is available for any of those arrestees who choose to avail themselves of it. And we're doing the same thing with regards to our deflection program that is operated by our Tucson Police Department. They have collaborated with 2 different community-based nonprofit agencies that provide substance use disorder treatment, but also connect individuals up to medical care when they need it. So we have an existing network for anybody who's deflected, and we have a no wrong door policy. They can go to one of those providers, or they can go to our mental health hospital, our crisis response center, all of which have no wrong door policies. So if a law enforcement officer drops off somebody who's been interdicted, potentially, patted down and drugs seized from him or her, not booked into the jail but deflected, that individual will get appropriate medical care, appropriate screening, be referred to appropriate housing, and be transported there, and make sure that they have food. We think this is going to impede the spread of the virus, because we won't have those individuals violating the social distancing policies, going in for medical care in a way that's not coordinated for them, and exposing people if they are positive, or exposing them if they're negative and someone else is positive to the virus. So I think we've tried to get ahead of the curve, as we know from what's happening in other countries and other parts of the United States. Inevitably, it's not going to work perfectly. We are going to have people exposed and people who suffer, and some of whom will die, but we're hoping by getting a little bit ahead of the curve with regards to the deflection program and the release program of these individuals who are connected up with medical care, that we will be able to stem the tide. And one of the things I should say that really helps in this regard is that Arizona is a Medicaid expansion state. And so 99% of our indigent criminal defendants, which is 97% of all of our defendants, so almost all of our criminal defendants and arrestees are eligible for Medicaid funding for both behavioral health and for medical care. And so that really makes, I think, a significant difference for us in our community to be able to tap into those resources when they're out of custody. They're not entitled to those resources when they're in custody, but they are once they're released from custody.
That's great. And I do know that is a place where the ABA standards are also supportive, because our standards on treatment of prisoners require that anyone being released actually be told of their rights to access medical care and be provided with the contacts that they need and so forth. So that's really wonderful. And I do think is probably helpful. Are you all, is the Criminal Justice Coordinating Council, like, did they have now a medical advisor as you go forward? I mean, it's wonderful that you are not facing what New York is right now. But as you say, it could be coming. And as you kind of proceed to evaluate what might be next necessary steps, is that something that you're putting in place?
Yes, so our, as I mentioned, our Justice Coordinating Council is chaired by an assistant county administrator who reports directly to our county administrator. And our chief deputy county administrator used to be responsible for oversight of all the health departments. She's now the chief deputy over all departments. We have an assistant county administrator for all the health and behavioral health departments, and we have a health director. All of them are plugged into these efforts. We've been in communication with them, in collaboration with them, and through our county administrator, we're coordinating with the various health and behavioral health departments in the county. I should add, we're also concerned about crime victims during this time, and we do see an increase in victimization, particularly with regards to domestic violence and sexual assault as a component of domestic violence. We've been collaborating as well with the victim services agencies and with our health and behavioral health providers and the county leadership in that regard to try to address the needs of victims as well as of criminal arrestees and defendants.
And that actually raises a point that I want to ask Corey and Lauren, and Andrea, if you know this for other jurisdictions, feel free to jump in. But one of the questions posed on the Q&A is, what post-release are you seeing people coming back with new offenses? And is that is actually, is either the reoffense rate helpful to you in, or the lack of reoffense rate helpful to you in pursuing further writs, or is it impeding that because you are kind of seeing reoffense?
Yeah, I mean, Lauren, we haven't seen anybody, and we would probably know. Yeah, I mean, I haven't seen that fact intersect with our advocacy on this yet, but I will say we have had conversations, at a very early level to reflect on, in a year from now, Malia, as you referenced, the mayor set a goal to reduce the Rikers population to 3,300, which is still a lot lower, more than 1,000 people lower than it is today. These people should not go back, right? And kind of, one thing that we have seen, which again, it hasn't yet affected our advocacy, although it obviously doesn't hurt, is that crime rates are not going up. In fact, they're going down in New York right now. And so, I think that is obviously really telling and really speaks to the issues that Andrea framed this all up, of that fundamental question of why are we incarcerating these people to begin with. So I really think this is going to be, again, we're right now in the middle of the crisis, so it's hard to think about these big picture things, but it has already started to occur to us to think about this moment and what it really says about what a better criminal justice system can look like.
Right. And I mean, the long term, I completely agree with. I was just sort of curious, and the reoffense rates are important. I think all of us who work in criminal justice advocacy realize that one bad story, and look, I mean, this is part of what you're experiencing with bail reform in New York, right? And the pushback. One bad story can derail what might otherwise be a good policy, particularly if that story gets elevated. It is good to know that you have not faced that, but in your kind of planning for strategy, is that one of the things that you're thinking about, and is, you know, maybe one of the ways to do that is to try and track all the others and say it's an isolated case. That may be a big haul, but if you have strategies to address the kind of one bad example, let's talk about those as well, because I think people who pursue this may face that.
Definitely.
Could I just briefly, for a little bit of kind of, again, prior to this very strange and awful time, and it does look like, for a variety of reasons, crime rates may be going down right now. But even in the pre-COVID world, pretrial rearrest rates are overall very low. Like, I know that it is true that if tragedy happens, it is really awful, and that it can really set back the narrative, like you alluded to. But nationally, people accused of felonies who are released pre-trial, less than 2% of the time are picked up for a violent felony during the pendency of their case. And data that's driving the Arnold risk assessment tool shows that, you know, even the people who are flagged as the highest likelihood of arrest for a violent crime, again, arrest, not necessarily offense, even those people flagged highest risk have an 8.6% chance of being arrested for a crime of violence in about 6 months. So again, like, overwhelmingly, that's 91% plus of people do not get picked up, right? So it's just kind of a reminder that what we're doing out of that concern, which is completely understandable and part of the system, is over scooping up all these people and subjecting them to pretrial detention, and particularly now, just the calculus is so dire.
If I could just add also, for any sort of practitioners out there who are litigating this on an individual basis, I think for judges and prosecutors who do have concerns about return to court, about victim protection, I think it's helpful to remind judges and to remind the players at the table that there are many tools in a judge's tool belt other than a cage to address those concerns, right? So we've had, on a couple of our individual cases, we've had judges issue orders granting a writ of habeas corpus on the condition that our client remain in their home unless it's to attend a treatment program or unless it's to pick up medication. Judges have signed off orders of protection for complaining witnesses and other tools like that address the concerns that that judges and prosecutors bring to the table, but don't keep our clients in the dangerous situation that is jails right now.
Question, one of the reasons that people are so concerned about Rikers is because of how much of Rikers is dormitory style. And is that, you know, are some of these kind of more intricate details about how the system works critical to people seeking, particularly if you're talking about mass writs or negotiated pieces? Are there specific facts that you think that advocates and public defenders should know about how their system operates before they go forward and try and seek some sort of program of expanded pretrial release? And what would you kind of direct them to investigate?
Yeah, I mean, I think actually the answer to that is no. I mean, please do. I mean, if you may uncover that there are aspects of what's happening in your local jail that are particularly egregious and also need to be fixed. And that obviously has enormous importance for the many people who will inevitably remain incarcerated and that we will not be able to free with these strategies. But on the mass writs, we have really been leaning on the assessments of the correctional medical professionals, which is that you really can't, there is nothing you can do. You can follow the CDC's interim guidance on correctional institutions, which is out there, to the letter, and you will still not prevent the spread of this virus, which has a 15 to 20% morbidity rate for medically vulnerable populations, right? And so that's kind of that's a very simple point. And there's so much evidence for that out there, which you can find and copy and paste from the legal aid writ and from many other writs, which are being gathered. And I know, you know, the AC, there's a couple of different people that are creating Google documents with, you know, and every day there's a new example of an incredibly well written, many of them written by ACLU lawyers, I should add. As a former ACLU lawyer, I take pride in that as well. And many written by great defenders, of which now I'm part of that community. And you know, I think I can speak on behalf of all of us when we say, like, use it and just cut and paste it. You know, I don't know that this won't work in federal court as someone who's practiced in federal court, but I will tell you in state court, we haven't even gotten our own expert. We've been citing other people's expert testimony, as well as all the stuff that's on the internet, you know, as well as the tweets of our own correctional systems experts, because, you know, in state court on an emergency habeas writ, you know, we get away with that stuff. I mean, so, and this is an emergency. So I think, and no one has questioned that. So push that and use that evidence, because it is there, and it is very persuasive on this point that you must release people to really protect them. And I think that's a very strong argument and an elegant one, and one that avoids, for those of you out there like me who have done prison litigation, the incredibly complex debates that we get into about what constitutes deliberate indifference to serious medical needs on a granular level. How many isolation, and especially because we're all in a new space here, even doctors are in a new space trying to figure out how to cope with COVID. You know, how many respirators does a correctional facility need? What kind of isolation units do they have to have? I mean, these are not questions that are easy to answer. I will say that if you do want to look at that at a more granular level, the place to start, I think, is the CDC's interim guidance on correctional institutions, which if you Google that, you'll find it. And that lays out a series of steps, which, again, for any of you familiar with prison administration or litigating about prison administration, you will look at that list and you will know that there's not a single correctional institution in the country that is actually doing all those things and is capable of doing those things. Not for bad faith, although that's out there too, but because, you know, our correctional systems are systematically underfunded and operate in dark corners and don't get the support they need to meet standards like that. So you can find you can start there as a place to say, okay, maybe I need to start asking, does my facility have a respirator? Does it have isolation units? What kind of cleaners is it using in the facility? Do they meet, you know, it's in the CDC guidance, do they have this percentage of these chemicals, et cetera? And that'll give you a kind of guideline for asking questions.
That's great. And we can add that, the CDC guidance to the materials for this webinar, and we'll do that. I want to turn to some of the questions being asked online that are somewhat specific. And let's start. Amelia, question for you on how significant you think the Macarthur grant was in Tucson's ability to form what seems to be an amazing collaboration.
I think the Macarthur grant arose out of an existing collaboration that we had developed through this Justice Coordinating Council, through a drug treatment alternative to prison program that our county attorney, Barbara Lawal, had initiated, and through some other collaborative efforts. But I think that the Macarthur Foundation grant to make us a safety and justice challenge site really moved us forward in a new direction and helped us meet more frequently, have more specific goals, be more targeted in terms of what we were doing in connection with reduction of the jail population in particular and addressing racial and ethnic disparities. So the funding primarily has been used to staff up our pretrial services division, and that has enabled more supervision for arrestees out of custody pretrial, facilitated our ability to help use our pretrial services division to help find housing for the homeless individuals that we released last week and we anticipate releasing this week. So those funds have been helpful in that regard. The other thing is we developed through that Macarthur project a community collaborative that includes a majority of community members who are not part of the criminal justice system agencies. So those of us who are agency heads and assistant heads of the agencies are a minority on that collaborative. It meets on a quarterly basis now, for a while met more frequently, but we have leadership from the faith community, from the nonprofits that serve both victims and defendants, re-entry coalition members, those sorts of things. And so we have a broad network that we're able to tap into at a moment's notice of agency heads and leaders who know one another, in the health departments, in the behavioral health departments, in the nonprofit world to provide housing or treatment or food, transportation, those kinds of things. I think it made us fearless in terms of going forward in the light of COVID-19 to know that we could make what we wanted to have happen because we knew who to contact and knew that they could make it happen for us. And that if we, just made a few phone calls, sent a few emails, had a couple of Zoom conference calls, we could get it done. And that's how it worked. And, and that and a lot of what would have been shoe leather and is now, computer time, but we did have a lot of people working nights and weekends to make what we had happen last week and this week happen. And, I think part of the willingness to do that was the trust level that it's going to be for something valuable because it's part of this cooperative, community-based group that works together on a regular basis.
That's wonderful. I want to ask a question based on what you just said. That's also a question posed in the Q&A, which is what can pretrial service agencies do to emphasize the importance of these releases to courts and also to support those releases? And I guess that kind of raises a kind of more basic question. In Tucson, you had pretrial services who were supportive of this effort. Corey, with the probation violations question, I think it's a legitimate question to say, is pretrial services in New York supportive, helping, and what are they doing?
Well, I would separate, we have, pretrial services for us could mean two things. It doesn't just mean parole. Yeah, I mean, I think I continue to have nice things to say about the state parole system right now, but the city, the city has been more engaged on this. And Lauren, I don't know if you have any more specific information about this, but coordinated through the Mayor's Office of Criminal Justice. And, they are sitting in this system. And I think they are engaged with this question. So I think a lot of that, I think they have been in general supportive and thinking about these things. I don't think I wouldn't want to put them in the same bucket as the state parole system for sure. And it is essential because, again, it really goes back, it takes me back actually to the bail reform conversations and how critical their engagement on bail reform has been. Because we, to make a system work in which you have a real shift away from incarceration as the default for people pre-trial really has required their engagement as well. So they are definitely a player that needs to be involved.
That's great. I want to give anyone who wants an opportunity for kind of a last statement, advice for advocates, organizations that are behind you all, either because the spread has not come or just because they're not as engaged yet in planning for this. Any kind of last statements you all have? Andrew, do you want to go first?
Sure. This is something that, I mean, every day that we're in this fight, I think my understanding of it shifts. But some good advice I'm hearing from lawyers who I'm working with that I've found to be a really useful reminder these days is like, a lot of us are used to, you wouldn't file something in court unless you knew it was perfect, or you had at least, satisfied yourself that you'd done enough research or consulted with enough people. And this is not the time to make all of your pleadings perfect. It is really a matter of advocates teeing these issues up and getting whether it's executive authority, judicial authority, like anyone who can do something to have just like a vessel served up to them. And so I've been trying to remind myself of that because it's a very different way of my litigation operating. I think that's true for a lot of folks, although certainly criminal defense attorneys are used to having to roll with all kinds of punches all the time, and I admire them greatly for that. But I just think it's like easy to kind of get in your head in normal litigation practice, and it's just a time to surrender and get stuff moving. And I'm urging people to keep this work going regardless of whether you have confirmed cases, but because the need is just going to be great everywhere. But I think it's true that there's a real reason to push before that, and that there's a window where the public health conversation is a little easier, and you don't have to navigate the complexities that Lauren was talking about of like finding quarantine environments for folks who might otherwise have one. Like, we should be doing that. It's essential. I'm so glad we are. I think there are going to be models coming out of Chicago that will be doing the same. I'm really working hard on Dallas, which has confirmed cases. But just like get over yourself a little bit and just push and do what you can, because that's what we're all here to do.
Thank you, Andrea. Yeah, Amelia?
Just one more thing to add. So last week, we had a meeting of all the prosecutors from the 15 counties across Arizona and a discussion of best practices to try to help in light of COVID-19, both internally within our agencies, in our interactions with courts and court hearings, grand juries, preliminary hearings, but also this notion of reducing the jail population, both pretrial detainees and probation violators. And our Prosecuting Attorneys Advisory Council is coming up with a list of best practices. We do have a lot of similar projects going on in some of our other counties in Arizona. I know that may be counterintuitive to some of you who are defense attorneys and know some things about Arizona's reputation, but I will say that in this regard, our prosecutors are pretty much all on the same page, and our sheriffs, trying to work together to come up with solutions and sharing amongst ourselves. So I would say to those of you who are defense attorneys, don't be shy about approaching the prosecutors in your jurisdiction and the sheriffs or whoever runs your jail, because they may be more amenable than you would otherwise think.
Thank you. That's a wonderfully positive note. Corey, anything you want to?
I mean, I would just underscore actually what Andrea and Amelia both said. I mean, Andrea, that so resonated with me. These are not the pleading we've shared. They're probably the pleadings I've written that will be the most widely shared in my career, and they're like the worst ones I've ever drafted. But but for good reason, and that's the reality we're in. We're in an emergency, and I think that the comments really jive up, because I think the one thing I would say is just to really underscore how the multi-pronged strategy is really the way to go, and that there are places that the systems actors will come together and do the right thing, and not to lose sight. As defenders, we sometimes lose sight of that. But that is where actually we're making the most progress. But also that the litigation helps push that process. And we often get threats from players saying, "Oh, if you litigate, we won't talk to you anymore." But I've been hearing that for 20 years of my career. That has never been my experience. And this experience confirms that actually the litigation both it brings attention to things for policymakers that, again, they're not acting in bad faith. They're in a crisis too, and they're dealing with 100,000 things. And we've got to elevate on behalf of our clients the deadly threat that being in a prison and jail right now poses, and that's a way to do it. And it also, frankly, gives actors political cover to do things that are quite complicated for them. And so but also the courts aren't going to save us, and so we've got to recognize that the solutions ultimately to this, the best and fastest solutions for our clients, do involve keeping those lines of communication open and really pulling all the levers that we can.
Lauren, anything you want to add?
I'll be brief. It's again aligned with what all have been saying, but we're obviously in unprecedented times. So like I've been having this conversation over and over again with attorneys in my office. That client that you have who's been incarcerated for the last 12 months awaiting their trial, who you tried and tried again, who a judge said no, 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 they might now say yes. So this is the time to push for those clients who traditionally you might not have had a chance to get out, but we're obviously in extreme situations right now where our clients' lives are literally on the line. And so we should be fighting for each and every one of our clients.
Thank you. I want to thank this incredible panel. I want to thank you for the work that you are doing. I want to thank you for taking time out to do this today. And we hope you enjoyed the webinar. I want to echo what Judy said, which is this is only possible through ABA membership. I know sometimes the ABA doesn't have doesn't feel as accessible to some of the communities that are most interested in these topics. And I hope that this is a really good indicator of the work that we are desperately trying to do to support prosecutors and defenders and civil rights advocates. I want to thank all our co-sponsors who are too numerous to mention, and we hugely appreciate them. Again, just thank you all for attending today. We will continue to add materials. Everybody who registered for this webinar will receive an email with a link to the materials and a copy of the recording. Please feel free to share it widely among your communities, and best of luck, everyone out there. Thank you, guys.